I've been given the word to go. I know you're all hugely excited and going to try and stay awake for all of this. So what I'm going to do is I'm going to give you a brief whistle-stop tour of the GDPR, what it means to everybody, and more importantly, what it hopefully means to you guys. So without further ado, and no drum roll. So GDPR, what you need to know. One of the things you need to know is that it's 1,693 paragraphs long. We're not going to do every paragraph this evening. And I'm going to give you the most important and salient points from that hopefully will be relevant for you, for your business, for everything that's going on. You can't escape data protection at this moment in the world. My name is Stewart Thompson. I'm currently a director of global privacy technology in a large internet company. I also consult into GDPR.ie. I was previously lead in GDPR for Watson Health. Previous to that, I worked in St. Vincent's Hospital Group, a little bit closer to home. And I'm over 30 years in computers and computer science and 15 years in data protection. So I'm in that since long before it was popular. So it's nice to be trooped out as an expert occasionally. So if I can get this clicker to work. So I'm going to start by telling you things that are happening with the Data Protection Commissioner over the past number of years to give you a sort of setting for what the story is. So in 2015, although you can't see it here, there were 950 security breaches. In 2016, there were 2,224. And in 2017, there were 2,795 security breaches. And just to explain, they're the ones that were reported. They're the ones that were known. There may well have been quite a lot more, as you can well imagine, but that is up 27% on that year. But the next important statistic is that in 2017, there were complaints, 2,642 complaints. And as you can see here, it's risen from 932 to that. And that's before data protection became very much the feature in both the news, in the presence and in the conscience of everybody that it is now. So it was up 79% in 2017. In 2016 there were 50 audits or inspections, and in 2017 there were 91, which is an 81% increase, and you can just imagine where that's going to go, and I'll explain to you now why that's the case. Basically for 2017, and I'll tell you about the 18 one, but basically 2018, the Data Protection Commissioner got a 55% increase on their 2017 allocation, which happens to be 6 times the budget they had in 2014, to give you an idea of the amount of funding that they have. Now you can imagine, as Ireland is pretty much the world headquarters of a lot of the biggest internet companies, they have a lot of things to monitor. There's Facebook, eBay, Google, you name it. Having said that, you'll see in a moment, but that's not where all of their focus is. Obviously a lot of resources are involved dealing with that at the moment, but not everywhere. They've recruited another 40 additional staff. They've 2 offices in Dublin, so they are expanding to get the space. But having said that, that's 4 times the staff they had in 2014. The focus is education, awareness, and the very last one, enforcement. They are more concerned about advising, guiding, as opposed to investigating and prosecuting. Having said that, like any regulator, they will do that. And there's a special focus on small and medium-sized enterprises. So while there is very public resources being expended on Google, Facebook, etc., they are also concerned about the compliance of Joe and Cynthia, a business person around the world. So recent news and prosecutions, and as you know yourself, you can't miss it. Cambridge Analytica, the numbers get bigger every day, but you can see what's going on. And Mark Zuckerberg was he's been in what you call interviewed by the American Congress as we speak. And it's just really interesting stuff. The other thing as well is that, actually I didn't put in the one I wanted. But Under Armour. So Cambridge Analytica was 87 million. Under Armour was 150 million. And this thing is going ahead of me. Yes, there. That's the one I wanted. Under Armour, 150 million people's data lost in February. And I'll tell you why they'll all be happy in a moment that it was before that. AIB, closer to home. 500 people's data was left in a car park in Galway, and someone said, oh God, what's that, and dropped it into a local shop. The shop rang up, sorted it all out. But interestingly enough about this is that was a reportable breach, but the very next day the Data Protection Commissioner also issued a press release stating that they investigated and contacted AIB and were satisfied that AIB had all the necessary protocols, procedures in place, processes, everything that they needed to have in place. It didn't obviate the fact that this happened, but they were able to show that they had processes and procedures for handling data, that they had data breach protocols, they had everything in place, so it lessened the impact. But like I said, it didn't stop the actual thing. Equifax, 143 million Americans, and as we know, many millions of Europeans and many thousands of Irish people involved in that. The Royal Free in London, they did what they thought was a very laudable, very well-meaning sharing of data with Google Analytics and Google DeepMind. 1.6 million patients' data from their emergency department were shared with them to look at better care, better paths, better flows, to look at how they might improve their ED service. And eventually someone said, did we have the permission of the people involved to share that data? Both Google DeepMind and the Royal Free got fined and prosecuted by the Information Commissioner in the UK. The fines were in the order of between £150,000 and £500,000, which is a lot of money in anyone's language, obviously a drop in the ocean for Google. But if that happened after May the 25th, the fine for Google could be in the order of billions, because it could be up to 4% of their global turnover. So just sort of put it in perspective why there may be a raft of reports before the date over. 30,000 Irish teachers hit by a union breach in September 2017. Musgraves targeted by cyber attackers. It's out there everywhere. So, just to put that in place, Helen Dixon says, and unfortunately I think we will be able to get the video here now. As Helen Dixon says, it cannot be business as usual for any type of company or public sector body after May 2018. If it is business as usual after that point, there will be consequences for companies and organisations, whether they are big or small, public or private, and those consequences will be very significant. Now, it's not all about, woo, they're coming to get you. It's about encouraging people to be compliant and handling data. The GDPR is all about putting the person, the data subject, at the centre of it. The data subject owns their own data. Anybody, an employer, only holds the data for that data subject, their employee, in trust, and are supposed to protect it and preserve it. Likewise, Google, Facebook, whatever, if they have your data, that's there, and it's for them to mind it and have it processed for you. Just to tell you a little about the role of the supervisory authority, and I'll whiz through this. A mandatory role under GDPR, responsibility for monitoring and enforcing the regulation, promoting public awareness, and that's what I was saying. I mean, you'll see Helen Dixon on a lot of things at the moment, and travelling around the world, banging the drum and advising people, advising Parliament and government, promoting awareness for controllers and processors, providing information on data subjects and their rights. And I'll go into this at the moment. Data subjects have a lot of rights, and as I said, the GDPR is all about the data subject. It isn't about you, it isn't about your business. It's about you as an individual, but it's not about you, your business. The Data Protection Commissioner handles complaints. They cooperate with the supervisory authorities to ensure consistency, because obviously there are 28 supervisory authorities in Europe, soon to be 27 if Britain get their way. Encourage improved codes of conduct, certification and standards, so therefore they can have that within the business, and conduct investigations on the application of the GDPR. And as you see, conducting investigations is only one of the many tasks and various other tasks. So now what I'm going to do here, because we did have it embedded, is we're going to get Helen to speak for us. Let's see if this works. I'm going to flick to YouTube and then we'll have to go back. If it works. Come on, Helen. She says
we see the GDPR as heralding really a new era in the regulation of processing of personal data. And by that we mean that the GDPR is bringing in amplified and expanded rights for individuals to control their destiny in terms of the data that's collected and processed. And then correspondingly, it's putting a whole range of new obligations on organisations that collect and process personal data to ensure that they're meeting those rights. And on top of that then, for data protection authorities like the Irish DPC, it's giving us a whole new enforcement focus. We're going to have a range of sanctions we can impose on organisations that contravene data protection legislation, and we're also going to have the capability to impose very large administrative fines. So really, the GDPR is about putting the individual much more in the driver's seat now, and organisations are going to have to respect that individuals have a right to know and understand what personal data is being collected and processed, how long it's going to be retained, and for what purpose it's being collected.
Okay, I'll get out of that now and get rid of it. And now go on to the next slide here. Sorry, I had to jump out of it there. I have to get this to catch up with me. Don't you love technology, guys? There we go. Yes, current data protection rules. So, data protection is not new. As I mentioned, I'm actually working in it 15 years. And in fact, the original data protection law in Europe was brought out in, 1985. 1995. Yes, that's okay. I'm a decade out. 1995. It's called EU 95. And as you can imagine, in 1995, there was very little internet. There was very little digital footprint. It was a different world then. It was mainly paper-based, not so much computer-based. And if you think about it, iPhones are 10 years old. Facebook just celebrated 10 years. So 1995 is a millennia ago. But these are the data protection rules that are out since then. There's only 8. There's not 8,000, there's only 8. And as you can see, it says, obtain and process information fairly. Keep it only for one or more specified lawful purposes. Process it only in ways compatible with those purposes. Keep it safe and secure. Keep it accurate and up to date. Ensure it's adequate, relevant and not excessive. And that's, for example, if you're hiring a car, they don't need your blood group. They just need to know who you are, your driving license and your credit card. Ensure it's adequate, relevant and not excessive. Retain it no longer than is necessary for the specified purpose or purposes, and I'll get into that in a while in terms of retention, and give a copy of his or her personal data to individual on request. Those rules are in force for 22 years. So people had a right to get a copy of their data for the last 20 years. It's not new. The data protection laws, and you'll see now what's the GDPR. So that's GDPR. What's changed? There's now only 6 principles, not 8. One is process lawfully, fairly, and in a transparent manner. Sounds like the old rule. Collected for a specified, explicit, legitimate purpose. Sounds very much like the original law. Adequate, relevant, and limited to what is necessary for the purposes you need it for. Once again, similar. Accurate, and where necessary, kept up to date. Once again, similar, better wording, but strongly worded. 5. Kept in a form which permits identification of data subjects for no longer than is necessary for the purposes for which the personal data is processed. I'll explain that in a moment. And 6. Processed in a manner that ensures appropriate security and personal data. So 8 rules became 6. So, what is it all about? Which I'll get into now in a moment. But they are the 6 principles of the GDPR, replacing the 8 principles of the original Act. And one of the main changes, but not the only one, is this one. The controller shall be responsible for and be able to demonstrate compliance with the principles. So now you must be able to demonstrate that you're compliant. And Helen Dixon, when she was in Washington at the Worldwide Privacy Congress just recently, banging the drum for GDPR in Europe, stated that one of the areas that she wants to focus on is transparency. And transparency means that you are telling everybody whose data you hold, both your employees, your customers, and anyone you deal with, who you are, what you do, what you collect, what data you hold on them, how long you hold it for, what you do with it, and how you get rid of it when you're finished with it. So it's important to be transparent, and you'll see where that comes in later. And that's every company has to do that, whether it is a Facebook or it's your local engineering firm or construction company, both for their staff, and remember, staff are people too, plus your customers. Okay. So the GDPR, what's it all about? Well, it was adopted on the 14th of April 2016, so it's not new, and it replaces all existing European data protection laws from the 25th of May 2018. It's a regulation, so it's directly effective. Now, local countries did have to bring in local laws to bring it into force with a certain amount of interpretation, but basically one law, all Europe. No changes, no locales, one law, all Europe. And the intention of it was to harmonise privacy laws and to bring it up to date with the modern digital age. That's really what that was, to bring it all up and add quite a lot of other things to it. So first of all, it's mandatory, not optional. Can't do it. It's not for the big companies. It's not for Facebook. It's for everyone. It applies to all companies that process data, and not just companies. Your local sports club, that type of thing. Everything that processes data and holds personal data are under this. It imposes obligations on companies to do things which I'll go into in a while. And you must be able, as I said, to be able to demonstrate and evidence compliance. Not just say, no, we look after everything. We've got firewalls. We've got a good IT company. You almost have to have, like you have to have HR, a compliance file. You'll need to have a number of things which I'll go into in a while. So EU citizens' rights are harmonised and extended. So requirement for consent must be freely given, specific, informed and unambiguous. Tick boxes don't count. People need to know who you are, what you do and how they do it if your processing is based on consent. Consent is only one of 6 legitimizers for processing. It could be on foot of a contract. There are many other reasons for a legitimate interest. There are many reasons why you will process data. It isn't all about consent. They can give or withdraw that consent for any purpose or for anything. So I might say, you can have my data for building my extension, but you can't have my data for whatever else it may be, a secondary use of some nature. So we can specify that. They have to be informed of all types of processing, like I mentioned. They have to be able to give an access to their data, a copy of their data, to be able to rectify their data, ask for their data to be erased, object to processing. They need to be given an insight to automatic decision making. I don't imagine many of you will be doing that, but if that's the case. And then any transfer of personal data to another provider, they must be able to be ported from one business to another upon request. The broadened scope of personal data, not directly applicable to your industry. All direct and indirect identifiers. So in other words, it doesn't have to say Stewart Thompson, 21, the drive. If someone can derive from the information that you have that it's me, it's then personal data. So just having my number, which obviously would be 007, whatever that number is with the relevant data, that if someone can identify me from that, that's personal data. So just to say, it's not just name, address, telephone number, and date of birth. Also, behavioural or derived and self-identified data, so it could be genetic, cultural, social, economic. Once again, perhaps not applicable in your environment, but just to know. And it's format and technology agnostic. It's not all about computers. It's about all data you hold, structured and unstructured. The organisational impact of the GDPR. Data controllers and processors are liable for breaches. So if you share data with anybody else, you're a payroll company, someone's doing payroll for you, or you have your CRM in the cloud with Salesforce or some other thing. They're your processors. You must have a contract in place, and they are also liable for the data. Like I said here, data controllers are legally bound to validate processors' compliance. So if you are using cloud-based software or other software, you must be checking with your suppliers that their software, in the cloud or otherwise, is GDPR compliant, that you can get a copy of data out of it, that you can satisfy subject requests using the software that you have. So if you've got practice management software, other software where you keep people's data, your staff or your clients, you need to be able to satisfy the subject rights, which I'll be coming to in a while, out of and with this software. Some companies would have to have data protection officers. Doesn't apply most likely in many parts of your business and your field. There's stringent data security and breach management requirements from the GDPR. There are conditions for cross-border data transfers. Cross-border typically means outside Europe, for the want of a better word in terms of the way we're looking at it, or in the not too distant future between here and England. And there's a requirement to demonstrate compliance. I mentioned that. The increased cost of non-compliance is getting, I think, an unfair but a quite right emphasis in the whole thing. The fines are up to 4% of global turnover or 20 million, whichever is the greater. Having said it, the fines will be proportionate, both proportionate to the company and proportionate to the offence. So for some businesses, 50 grand is 50 million euro. So it depends on the business and the nature of the offence. So be assured that the fines will be commensurate to the breach and to the size of the company. So now just give you a quick thing, because there's always a confusion over controller, processor. What am I? Am I a controller and am I employees, processors? The controller is the person who controls the data. And by that they mean is makes decisions about it, decides how it's used. And a processor is somebody who processes them on behalf of the controller. So for example, Company A is a controller. They've got staff. They deal with customer records. Company B is a processor if they're a contract payroll company, if it's Salesforce running your CRM, or if your architectural drawing thing is in the cloud. That company is a processor and there should be a contract. All your staff, because they work for you, are also agents of the controller. They're controllers, not processors. Your business and your staff are part of the controller. And the data subject is your staff, you, and every living identifiable individual that you deal with. So they're the three main terms: controller, processor, and data subject. Process information. So processing information is everything, including getting, retrieving, storing, archiving, anything you do with information. It's not just doing something with it. Having it sitting still in a database is considered processing. Storage is processing. To disclose is to share data between entities. So if you're lucky enough to be a multi-branch entity or whatever it is, sharing data between your branches or between your business is disclosing, and between you and other businesses. But transfer is when it leaves the jurisdiction or the state. Okay, so that's disclose, process, and transfer. So as I said, the focus is on the rights of the data subject, and you'll now see that the data subject has a right to be informed, and that's where to be informed who you are, what you do, how you hold the data, what you do with the data, what data you hold, who you share it with, how long you keep it, how you raise it, and how you protect it. So they have the right to that. They have the right to access. Hello, can I have a copy of my data? Now, it won't be a phone call. I'd have to give you a written request or an email. You'd have to satisfy that it's actually me, but you must give me a copy of my data. And under the GDPR, that copy of all my data that you hold has to be given to me for free and within 30 days. Okay. The right to rectification. So I can then turn up and say, that's not right, I want that changed. So you must be able to change or rectify my data. The right to erasure and the right to be forgotten. Once again, one of these other areas that I feel has undue highlighting because of the sort of famous cases in Google. But if you think about it, if I contact a medical professional or I contact someone and say I want my data erased, it's not an automatic right and it's not an instant right. For many reasons, for example, I'm an employee, I've just left. and I'm saying I want my data erased, maybe I had a disciplinary something in the files, you will be, for example, quite right in saying to me, well, Stuart, I can't do that because I must maintain your tax records for 6 years. I must hold on to your personnel records for the potential defence of a claim for up to 6 years. So there are many other reasons why data might be kept. You may have also some regulatory data to do with compliance or stresses, or when you design a building, you must be able to show evidence that you stress tested, like that. Unlike that bridge, I think was it in California, that they'd only just put it in and it fell down on those poor unfortunate people in the cars. They had to prove evidence that they stress tested. Rights restriction of processing. So somebody can contact you as a data subject or an employee and say, I don't want my data used for this anymore. Don't use my data for that. The notification that's part of the thing I said earlier, whereby the notice whereby you must be able to tell me what data you use. The notification is if you share it, if you transfer it, or if it's processed by others. I must be able to know about that. The right to data portability, once again, probably doesn't apply in the environment you work in, that I can request that my data is ported in an electronic format from one supplier to another, and you must adhere to that. The right to object to processing, it's similar to restriction. I object completely to processing, stop doing it. The right to object to automated decision making, obviously that potentially doesn't apply in your field, but I can. And then the right to withdraw consent. So if you're processing my data on the foot of consent and I withdraw my consent, you must stop immediately. You can no longer process my data. Okay? And just to give you an example of how that looks, you've got here that an individual can grant consent, revoke consent for a specific purpose, for a general purpose, for a period of time, for a group or a category of solutions, or when certain conditions are met. So that's to do with consent. I can request withdrawal of my consent. I can request erasure of my information, restrict processing temporarily, permanently, for a period of time, for a group or category of solutions. So there's many requests I can make. I can object to processing. I can ask you for a copy of my data. I can ask you to correct it. I've done these already, but this is a nice graphic, which is very handy. Request a report, why my data was processed, who processed my data, what data was used, how long are you keeping it, where copies of my data are, and if my data was used to profile me. I can ask all those questions, and you must answer all those questions. To receive notification of my data is shared with anybody. And then for minors, there's a very specific section in the GDPR about guardians, having guardians consent, evidencing the consent of the guardian for holding that information, and then when the person turns the age of majority, to consent the individual themselves. So they are the rights of the individuals, they're the rights of all of you, they're the rights of all your staff, and they have to be adhered to. And lastly, lodge a complaint. And you would have seen from earlier on that the Data Protection Commissioner last year had 2,600 complaints. I imagine this year it'll be a lot more than that. 56% of those complaints, by the way, last year were subject access requests. I asked for a copy of my data and company X didn't give it to me, or company X only gave me some of the information. I know there's other information they didn't give me. So that's just to say that that's what 56% of the complaints were. So these GDPR articles have created a new operational requirement for all businesses to facilitate these requests electronically where possible, within a specified time period, have demonstrated record keeping of the requests, of everything that goes on within the company, and must communicate clearly. So gone are the days of the click here to accept our terms and conditions, and it's a 17-page document where on page 16 in microprint is that we own you forever or you owe us a pint of blood. It has to be in plain, clear English at all times. We are, we do, we collect, we share, we do this. If you want further information, click here. So they're encouraging clear language at all times. It must be there. Just recently at DataSec 2018, which I think was only just on Monday, Cormac? Just on Monday. Helen said, now is a better time to start getting ready than later. Start with Article 30, which I'll tell you about in a moment. Article 30 is the requirement to document everything that you have, and then do a risk assessment, and then prioritise and sequence actions that your organisation needs to take. They need to have a clear internet system for staff, disciplinary actions for employee misuse of data, and a plan for exiting staff that would have had access to data. Linked to that, transparency, which is the theme she said will be our theme for 2018, that companies that have privacy statements, that are clear about what they're doing, that have everything in place, that look, and forgive me for saying this, as if they understand and are adhering to the law, are more likely to be the companies that are adhering to the law. Article 30 of the GDPR says every controller, and where applicable the controller's representatives, processors, shall maintain a record of processing under its responsibility. And you must have that. It's an obligatory document to have, and you must put those in place. Just a couple of points on collecting personal data. So we mentioned adequate, relevant, and not excessive. Adequate. Assess whether you're holding the right amount of personal data. Sometimes when you're dealing with clients, you get loads and loads of data and you have it there in case you might need it. The GDPR states you must only have the amount of data you need to do the function. Nice haves, or that'll be useful, or if I had this. Data minimization is part of the GDPR. You should only have the data you need and you should only hold it for as long as you need it. And after that, you must get rid of it. That's the rules. You must be clear about why you're holding and using it. You should take into account this may differ from one individual to the other, different job to another, different type of individual. You've got to keep that in mind. Relevant, as I mentioned earlier, only relevant to enable to achieve their specified purpose and not excessive. So I've gone around the house with this a couple of times. And then, as I said, be clear what you hold, what you collect, why you collect it, what you do with it, who you share it with, and how long you will keep it for. That's your privacy statement. And controllers have no basis for collecting or keeping personal data that they do not need. And I've said this already. And once again, you cannot collect or keep any data that on the off chance it might be useful in the future. And we all are guilty of that in many aspects of our lives, not just business. So here's an example of some of the privacy documents and policies that you may have required in your business. It starts with a privacy statement on your website, displayed prominently in your company premises and available to your staff and your customers. Evidence of appropriate consent or a legal right for holding the data you have. Details of all personal data held, Article 30. Details of all processing and data flows, you have to have that. Data retention policies and evidence of enforcement. So if you say you keep data for 6 years, and I say, well, show me what you do with it after 6 years, and have you done anything with any data at the moment, or do you have any data over 6 years now? Evidence of privacy by design. That's another requirement of the GDPR. If you're going to do something new, you must first of all think about the privacy impact for both your staff or your customers. And you have to show evidence that you thought about it, so you've got to document it, and you've got to ensure that it's built into everything that you do. You're changing your software, you're upgrading something, you must have evidence of that. You must perform privacy impact assessments on all new processing. Once again, thinking about the individual and demonstrating that's the case. You must have evidence of all the security measures employed within your business, whether it's password control, you've got firewalls, you have timeouts on your machines. You must have evidence of those, and they're known collectively around the place as TOMs, or technical and organizational measures. How do you protect the data you have? Don't have the password stuck on a sticky on the front of the thing or under the keyboard, that type of thing. You must have policies and procedures for all that and evidence it. You must have a data protection policy for both your staff and for your customers to see that shows how you actually enforce the principles of the GDPR. You have to have a breach management policy. And under breach management, and I don't go into it too much detail here, it's mandatory to report all breaches now that involve risk to the harm or privacy of individuals. It's mandatory to do that within 72 hours of becoming aware, rather unlike, Uber, who had a data breach of millions of people's data in 2015, decided to try and pay the hackers to bury it. And last year, towards the end of the year, basically it all surfaced that it had happened, but they tried to bury it. So let's just imagine if it was after the 26th of May coming, the fines for that would be quite substantial. You have to have policies for data subject rights. Mostly data subject rights are exercised by subject access requests, whether that's an employee saying give me a copy of all my file, whether it's a customer or an individual looking for a copy of their data. And you must have a policy and procedure, and your staff and customers must be aware of it. And you must have evidence of training and training logs for all staff. So everyone needs to be aware of it. They need to know what to do. They need to know what the GDPR is all about, what their obligations are, and what your obligations are as a company. Article 40, which applies to some things. We're dealing with some associations at the moment in Ireland, where it has been recommended from the GDPR that associations, groupings, or professional groupings should put in place an code of conduct. It's getting bad here. A code of conduct for the compliant handling of data. It's recommended that the associations do this so that all their members then have a guiding document and a public demonstration as to how they and all their members handle the data. So, what are the top 10 things? We're getting to the end now. What are the top 10 things that all controllers need to consider? Firstly, you need to be aware, part of being here today. You need to nominate someone in your company to at least try and drag you from your current position into a compliant state. Somebody who didn't step back quick enough, probably. You then need to know all data you hold and detail how you process it. That's the Article 30. You need to have privacy notice. Once again, If you have one, is it sufficient? Is it GDPR compliant? Do you have one on your website? Is there something on your premises? Are your customers aware of it? And are your staff aware of who you are and what you do? Can you facilitate individuals' rights? All the ones I mentioned earlier, copy, erasure, etc. And you must have policies and procedures for that. Can you handle a subject access request? You have 30 days from the time of a request to facilitate that request, to give somebody back 100% of all the data you hold. Can you handle or how do you handle or obtain consent if that's the basis of your processing? What do you do if there's a breach? Have you got a policy? Have you got a process? Do people know what to do? Are you implementing privacy by design, or do you do any international transfers? So the challenges for companies are time. I haven't got time to do all that. I'm busy running a business. I'm trying to get on with, running a profitable and successful business. I haven't got time for all this. I really don't understand what's required. I have no idea. We don't have anybody in-house who does it. We're engineers, we're architects, we're surveyors, we are whatever we are. We're not data protection experts. It's going to cost me a fortune. I'm trying to run a business. I don't want to do it. How do I evidence compliance? How do I maintain compliance? How do I show that it's all working? These are all the challenges for companies and challenges you have to face, because non-compliance is not an option. And I would tell you that it's all about evidence. So as I mentioned earlier, it's incumbent upon a company to demonstrate that they're compliant, have evidence of compliance, and have documented policies and procedures. It's the only joke or laugh you'll have today. But basically, you're balancing lawful, fair and transparent. So you have to be that, a specified purpose. Things have to be adequate and relevant. They have to be accurate. You have to have adequate security. And like I said, only hold the data you need for as long as you need it. An awful lot of people, and I dealt in the medical profession for long enough, don't advocate deleting anything anytime. But that's not an option, although in certain cases it is. So why comply with the GDPR? Well, quite simply, first of all, it's the law. It'll avoid risk to reputation if anything happens with the data. It's protection of the trust of your employees, the public and your customers. It enables better decision making, makes good business sense, well, you won't be getting fined and everything, delivers business value, and lastly, what now for you? Well, I would suggest it's not this, if it comes up. There we go. That's not how, a lot of people would like to do that at the moment in relation to the GDPR. The good news is, remember, compliance is mandatory. Have you any questions? Don't all shout at once. I'm happy to go home. Be on the mic. Is it on? Nope. My trusty assistant Cormac is going to come up here as well. Cormac is one of the leading consultants in GDPR and also is a barrister, so that helps. Although we're not dispensing legal advice, but we are here ready in anticipation for any questions you might like to ask.
Is there anybody here from the Association of Consulting Forensic Engineers?
Haha.
Okay.
Guess what? We got your letter.
We have a letter from Ned Flavin, and he asks a number of questions. So, if you like, on their behalf, I'll just give brief background in relation to questions that he's going. He's saying that obviously a lot of they do, they're involved in investigations on behalf of plaintiffs and defendants, on behalf of solicitors and insurers. And he makes the point that there's a considerable difference in assisting a plaintiff case and a defendant case. I think it means there's a significant practical difference, because for reasons I'll give later, in some ways there's no difference. But he makes the case, and in case for a defendant, the engineer assured defendant and defendant's legal team will have a lot of personal data on the plaintiff. And in a typical accident litigation, he says, the defendant forensic engineer may have a plaintiff's life history, address, date of birth, age, marital status, occupational history, professional training, previous employment, details of the accident, witness statements, photographs, drawings, CCT evidence, accident report forms. Medical notes may include previous injuries, injuries sustained in the accident itself, which is obviously essential for investigating the actual accident, medical attendances, records of psychological trauma, etc. And then training records, which may be very relevant indeed, driving licenses, safe pass cards, CSCS cards, training attendances, that type of stuff. And as he says, that's not an exhaustive list at all. Right? And any of the above material may also have third parties, co-workers, witnesses, supervisors. He makes the point that plaintiffs and defendants might not actually have a full realisation, or any, I suppose, of the extent of the information that's built up in that case file before the court. In the first question, obviously to do our job thoroughly, we must have and hold of this information, though frequently some of the details are distractions from the kernel of the case. There's actually a contradiction in that statement, because obviously we must have and hold of this information, and then some of the information is a distraction. And really, the interesting thing is that whilst you're doing that particular job, you're a processor. You're acting on the instructions of the solicitor who is conveying to you, in general, what the insurance company want if you're on the defendant side. Your client might actually be a company or a particular single individual. And you have, as an expert witness, you always have a duty to your client. But of course, the primary duty of a forensic engineer in a court scenario, acting as an expert witness, their primary and overriding duty is to the court, always, without exception. Never changes. But as Stewart was saying earlier on, one of the requirements of the Data Protection Act is that the information you should have should be adequate and not excessive. It's adequate, relevant, and not excessive. Some of the information that's been suggested by Ned Flavin, the president of that group of engineers, is quite obviously, and I say this both from his own comment and from the point of view of a practicing barrister, the engineer doesn't need it. And in fact, the solicitor should be sifting that and reducing the amount of information given. But the reality is he's going to get it. So the first question he asks is whether using this information in reports and correspondence amounts to data processing. The mere fact of having it is data processing. Using it is definitely processing. But once it arrives on your desk, you're now a processor. You're now a processor. Insofar as there's personal data in there, you are now a processor of it. There's no doubt about that. There's no equivocation. You're a processor of that personal data. You may only process it on the instructions given to you by the solicitor in the contract that you should have with you. And a lot of insurance companies are insisting that the experts employed by solicitors do have a contract in place. And if they haven't done so already with you, they will. I can tell you now. Next question he asks is, does a plaintiff taking a case, and he says, against, let us say, his employer, surrender some data protection rights? I'm not sure that the word surrender is correct, but does he lose some? He may not willingly surrender them. He may actually willingly do so. But whether he willingly does so or not, yes, some of his data protection rights are gone, because he may have given some information to somebody to use, and now he wants to draw consent. I don't want you to have to use that information again. And the answer is, sorry mate, I need to use that information to defend the case you're taking against me. So no, you're not getting it back. I'm not erasing it. I'm not doing anything. I'm just going to use it to defend the case. And there's nothing he can do about that. The purpose and use of the data has now actually changed. And the solicitor and the defendant is perfectly entitled to use that. It is already significant case law that a party to proceedings does lose in relation to medical records, and any in the field will have heard the case of McCrory, where yes, once you take a case against somebody, your medical records become part of the case history and part of the case file. You can no longer claim the confidentiality insofar as it relates to the injury about the case. And in a very recent case, just before last McP, a defendant's medical history became relevant to the issues, and that was disclosed. So his privacy and confidentiality rights and what otherwise would have been his data protection rights disappeared. So yes, they do change, right? Next question he asks, how should we manage and secure such data and information in the preparation and running of the case? And Stuart has actually already answered that. He mentioned that wonderful word TOMS, technical and organisational measures. You must have within your practice technical and organisational measures in relation to all personal data that you have, for whatever reason. And the next question...
just to say what I was saying there earlier, that effectively is a policy, a procedure, a password policy, evidence that you use it. You must be able to evidence that you have that. So not just having them, you've got to be able to evidence it. So that's really what that is. So it's not rocket science. You probably all do it, or a lot of it. You just need to have evidence. Okay.
Next question is very specific on what do we do when the case is settled, and the one after was right, when do we shred paperwork or delete the files? If you can just look at that, you know, what do we do when the case is finished? And really it depends. As everybody I think knows, most cases do settle. They don't go any further. They get to a particular state, the steps of the court, and then they settle. It should be in the contract that you have with your solicitor, stroke client, that when the case settles, you return the file to him and you shred or erase everything that you have in relation to the personal data of the party for whom you're acting, keeping only that which you need to keep. And you will obviously need to keep things for your personal financial records, for your insurance, for VAT, for all of that. Those records you keep because they're not. But you don't need personal. You may have the name and address. It might be an individual that you've been asking for. You might need to keep their name and address. You certainly don't need their health data anymore or any of their records of training. All of that stuff's now irrelevant. The case is over. So only keep what you need to.
But however, some people may say, well, what if it comes back, or what I need to keep it in case something happens in the future.
This is settled.
I understand. I hear you.
Yeah, and that's
why the lawyer.
Yeah. The next thing is, what happens if it doesn't settle? What happens if the case runs? Then you're going to have a whole range of different retention periods, because as it's settled, can it be subject to an appeal? How long will an appeal go? Do you need to keep it? You probably do need to keep it for longer than the appeal process might be. The case might finish and then you're waiting for a reserved decision from a judge. And that might come in stages. So you're going to have to keep it for particular lengths of time. It's a matter that you're going to have to actually sit down and work out, and your solicitor will have good ideas and he'll tell you quite often, well, I need you to keep that. I need you to hang on to that. You can also have a case for a situation where instructions are withdrawn from you. You might be terribly worried as to why they're withdrawn. It might be the client saying he's not happy with you. You're going to have to watch the case, but you might have to return a lot of the data and then keep a copy. But you'll have to tell your solicitor that you're doing that, lest there be action against you. Again, there are things you need to sit down and think about, and we wouldn't be able to go into them all here. And
just one other thing, the important thing for any business, not just forensic engineers, is to have a retention policy.
Yep.
And to enforce that retention policy. So an example of employee data, and unfortunately there are a lot of different regulations on employee data, but just to take that as an example, tax records need to be kept for a certain amount of time. CVs are recommended to be kept for a certain amount of time. Unsuccessful applicants, disciplinary files, it's a whole minefield of information. There's guidance and records of suggested retention times. We do require to have both a retention policy for all those different types of data, and I'm only just talking about employees at the moment, and you have to have evidence that you enforce it. So if you keep unsuccessful CVs for 6 months, you've got to have evidence that you have a process and that you have shredded CVs after 6 months, or that if an employee leaves, you will hold on to their data for 3 years or whatever the period of time it is into which they may have a legal right to come back at you at this whole thing. But just one thing to mention, and this is where advice is important, it is not prudent or allowed or recommended that you hold on to data just in case something happens. Just in case isn't a good enough reason to keep it. So that's something just to remember for your own things. But having no retention policy is an offence. Having a retention policy and not adhering to it is an offence. So these things need to be considered, and that's just to mention. So as you can see, unfortunately it's a minefield, but the point is that if you sit back and think about it and put some thought into it, having the documentation that I mentioned, the privacy statements, the regular retention, the details of what you're processing, etc., the retention policy within your business is all what it's about. Evidence, unfortunately, much like you have a HR and a compliance file, and doubtless as engineers you've got other types of compliance files you must keep, and other types of data you must keep to evidence that you stress tested something or whatever it may be going forward. Okay.
And just to complicate the issue totally for you, for forensic engineers, you need to think as to whether or not what you have done has had any input into any accident reporting that's been done under the Health and Safety Acts, where the accident investigation records or the accident records, as far as I know, have to be kept for 12 years. So it's something that needs to be held in mind when you're deciding these issues.
Right, so Anything else after that? 'Cause I've gathered there's many different types of engineering. Any other questions or anything you'd like to ask?
Actually, sorry, Stuart, just while we still not to dominate with the forensics.
Hello.
Just if I could, one further question on that. Again, this is obviously a very hot topic amongst engineers in general, and very much particularly to the forensic engineers, because the intensity of the data that we seem to receive
Yes.
and the sensitivity of it. And when we're writing these technical or techno-legal reports, we are, I suppose, reluctant to just trash them at the very end, because there's quite a lot of IP within the reports, the research and the data that can be of value in subsequent investigations. And rather than shred the whole thing, is there a way of, if you like, of sanitizing and keeping the IP? And one of my colleagues suggested during the week that he was going to embark on a new protocol. Now, I think he was focusing on identifiable persons or identifiable personal data, and he was suggesting to himself that he would, whilst he would name a plaintiff or a defendant as a person and thing, he would give no date of birth, no address, and he felt, well, Joe Bloggs is Joe Bloggs, they can't track the person down. Yeah. Is that sanitized enough?
No. That's as detailed an answer as you need, and I'll explain why. Because the definition of anonymisation is that it has to be irrevocably anonymised. And irrevocably means that without any, if I was to combine that data with some other data, I could figure out who Joe Bloggs is. So even if we still using the name Stewart, there are many Stewarts in the world. There's only one of me, but there's many Stewarts in the world. Just saying Stewart did this or whatever, or even saying the plaintiff did that, what you have to be careful with anonymised data or truly anonymised data is that that has to have no opportunity to be recombined with another data source to identify an individual. So anonymous data is a very definite and it's clearly defined in the GDPR. Pseudonymized data is where you remove certain or many identifiers, and it must still be treated as personal data. And that's why under the GDPR, for example, IP address, which is just a series of numbers that your computer gets assigned when you're surfing the internet, or your phone gets as you're going forward, is treated as personal data because it is associated with you and could potentially, much like you see in these cases where they're tracking a phone on masts, and they're saying that that phone was Stewart Thompson's phone, so Stewart Thompson was there. There's been court cases, and Cormac will jump on me all over this, but just in general, that have had that as part of the evidence that, you know, the person was there in the vicinity of the crime area. So data that isn't particularly personal identifiable is now treated as personal data, not personal identifiable, but personal. So the sanitization, I can understand why the IP of a report, a particular accident, a review of how a car veered or how something happened, and when you look at a number of those accidents, you'll get to see a trend, and it may end up in an improvement in car safety or road markings or surface, and I take on board what you're saying, but the data has to be anonymized, and anonymized is you remove that, you know, it should not be able to identify the individual involved. Now, there is also public records, you know, 4 people tragically killed in an accident somewhere. There's a report about that which may prove beneficial in years to come with other reports on a safety recommendation or an accident black spot or some such thing. I'm generalising, but you know what I mean. So there is an idea where that data should be preserved and brought going forward, but you need to talk to your association who may guide you on that or seek advice. So just simply calling it just Stewart and not doing an address and a date of birth is not enough.
And that includes, let's say, a report over which we have copyright.
When you say includes a report over which you've copyright,
that report must be destroyed as well, even though it will be prepared by the practice, and we copyright over it, etc. Yeah,
I don't know, and I couldn't comment to the retention period. I understand what you're saying. I don't know what the appropriate retention period is for that style of information. You know, you can contact Paul or Cormac or chat to some people about getting guidance on that. And the one thing is, though, is there's no right or wrong answer, and forgive me for being vague on this. The important thing is to have an answer, a reasoned answer, to which you cite, we considered this, we decided that, therefore we did this, we consulted with this person, this is our policy and procedure. Worst case, someone challenges it, the Data Protection Commissioner, for example, challenges it. And you go, oh, well, my view is this, and they go, well, my view is that. You then have a situation. But if you have no reasoning, no evidence of why, oh, I'm keeping it white because I want to. Not good enough. Yeah. So evidence of it and a reasoned method of getting to that point is fair. Okay. Is that fair enough?
I could certainly envisage scenarios where it would be possible to anonymise, truly anonymise, the engineering sections of a report, and I can see a validity for keeping the actual report for different periods. but the actual report should in fact contain remarkably little personal data. And an argument might be made in certain regards that the name of the plaintiff and the defendant are a matter of public record in any event.
Yes.
So it's
Yes.
so that's what I was alluding to there. So
Yeah.
you're not harming somebody's civil rights or privacy concerns because it's a matter of record about the accident, guard reports, etc. But it's something that this is not advice, but you can see the. Anyway, but look, not to keep on forensics, and I do apologise for all of you who are not forensic engineers.
Well, that's another question in the data general. In fact, well, those that say most engineers will receive and transmit that type of information and files by email.
Mm-hmm.
And it seems to me that email is like nuclear waste. It's there forever. Even when I delete my emails, they're
Mm-hmm.
Vladimir Putin has them at least.
Mm-hmm.
But they're in the ether. All engineers will have that.
Well, for example, do you think, as we talked about technical and organisational measures just a while ago, that if you transmitted a detailed report, with my name, my address, everything in it, just by Gmail, from your Gmail account to Fred's practice, for argument's sake, in a clear and open format, do you think that will be considered secure? What if it went wrong or went somewhere and somebody else read it? Would you feel as if you had done everything required to protect my data?
Answering that question might incriminate.
If someone was to do that, these random people of which I require, I
Is
think
the
you know the
gentleman-
answer. It's a two-letter word, isn't it?
Well, yeah, I suppose I'm asking a question because I'm worried about it. Yeah.
Yeah. Where personal data is concerned, right? Realistically, now we all email, "Hi John, how's it going? Going on holidays?" That's a general purpose email. But where you are handling sensitive data like that, cases, and you should be looking at encrypting or password protecting those emails. You should be looking to have a policy and procedure about how you do those communications. This does not have to get in the way of how you do your business. Okay, so just to say, it's not providing a layer of complication, but you have to understand that if a very sensitive file on a person was emailed to the wrong person, and whatever, how many people haven't accidentally emailed somebody something. So take on board that it can happen, and it does happen. If somebody takes exception to that, they can complain to the Data Protection Commissioner, and sure as eggs, they'll be at your doorstep the next morning.
Yeah.
And you go, well, I didn't think of that or whatever. So now you're showing custom and practice of not having the appropriate measures in place. So it is something that should be thought about.
But also it seems that there is a problem that even when we delete an email, we haven't deleted it fully.
I haven't been in computers for 35 years. I know exactly what that means. Having said that, there are ways and means of doing all those things if that's such a thing. Okay. Yes, sir.
How often can they fine you?
To be honest, obviously fines and the procedures under the GDPR will not be known till after the 25th. But at this moment in time, companies are prosecuted and fined under the current data protection regulation. You can get the Data Protection Commission's report from any 1 year. Typically at the moment it's mostly censure and publication of the details, and fines are very little, if any. Having said that, obviously come May, and Helen was quite clear in the YouTube clip that I played, which is normally embedded in the whole thing, in saying that this will happen. Fines will come into play, and government departments, every size of business will be fined appropriately. If you're repeatedly, if offences occur and you're being fined, whether it's £10, £10,000 or 10 million, one of the things they can do, the most important thing she could say, is cease processing. And cease processing means stop doing everything with data. Your business ends.
That seems to be the only.
If there's a blatant abuse.
The only practical reaction to this for small businesses is just get out of business.
I have been at shall we say, lectures and seminars around the country for some of the medical and professions, and I certainly have heard a lot of people in the room suggesting that it was time to hand over the reins and move on, because it seemed that it doesn't have to be burdensome. And I don't want to come out of this for people to think that this is hugely burdensome. It's definitely not simple. You do have to have policies and procedures. You need to be aware of it, and you need to think about the data you hold on your employees and your customers, and be shown to do practical things. You don't need to have a NATO level security defense system on your building and on your servers to be, appropriately secure. And it does say appropriately. The GDPR doesn't tell you how to do it. It tells you what you need to do.
I guess that's part of the thing. That there's a lot of kind of loose words there. It's like need and appropriate and adequate. And
Yes,
I mean,
it's principle-based
Who
activity.
decides what those words mean in any given context?
Well, I gave an example there of emails, and I sort of said, do you, like general public, do you think it's right to transmit reports with sensitive information between place to place without having a password on it? And the answer is no, it's not appropriate. So that's what I'm saying. So it's proportionate, and doing nothing isn't an option, as Helen says. Doing something that's proportionate both financially, technically, and within the capabilities of both the company and either the individual or the company is what needs to be applied. Doing nothing isn't an option. So you don't go to the native level and you don't do nothing. Is that fair? Right, thank you.
Can I ask you, what I'm confused on is what's the level of personal detail? For example, we've got a database full of phone numbers, email addresses. Is that personal
Yes.
detail?
All of that is personal data, yeah.
So we should have a policy that all that is deleted. So once we haven't worked with a client after 6 years, we should be deleting their email address and phone number.
Well, I'd even ask you, I mean, why do you think, have you a particular reason or indeed any reason for keeping it?
Well, I mean, for certain people, yes. Like, I mean, there could be an architect we do work with, and we want to contact them in 5-7 years' time.
Will they still be an architect? How do you know? They could have resigned, died, done
The only
anything.
way to find out is to call them.
Yeah, I suppose the thing is I mentioned about data retention and retention periods. You need to define retention periods that seem reasonable for the data that you hold. So you may only hold the data on your clients, whereas if you're designing extensions or whatever it may be, forgive me for, but whatever you do, you hold that for a certain period of time, and you define that period of time in line with common sense and any guidance that you get from regulators. Likewise, the professionals that you deal with, who you may deal with only every number of years, but that professional information is probably on the internet anyway, so it's public information, for the want of a better word. So you can have a certain set of rules on how you keep that data. So different data gets kept for different periods of time. And I mentioned the kind of HR data area as an area that has many, many types of retention periods. Likewise, you'd have many types of retention periods for different classes of professionals you deal with, different classes of customers. You have to have that. You need to have a reasoned way of doing it. It has to be documented, and you have to do it. So, yeah.
And just on, I mean, we're not forensic engineers,
I thought
but
everybody was.
we would mention, say, if we had a meeting with a local authority drainage department, and he is mentioned in one of our reports, that's a name that can be linked to a person.
Mm-hmm.
That data has to be destroyed as well, or how is that handled?
Well, you may state, for example, reports. We keep, let's just say, surveys, drainage surveys or engineering reports or whatever they're titled, for a certain period of time. You're not specifying what's in them. The period of time we keep them for is whatever X is, and after this time they're gone. They will contain maybe many people's name, because it was on Johnny's premises that I did the thing, and I met with Fred from the corporation, who we also met their consulting engineer and the insurance company. Yeah, they're all in it. They're all there. That information is germane to the report, it's germane to the information you have there, and you'll hold it for an appropriate amount of time, whether it's to do with an insurance claim or whatever it may be, and then you must get rid of it after that period of time. It does contain personal information, but the personal information is them in their professional capacity also, as
Even
well.
though the likes of that report is in the public eye anyway, in the planning file.
Well, then
or
that's,
whatever.
see, there's another thing you say, well, for these reports, which are just published on Deliri Ratdown, they're in a library of things in Deliri Ratdown. So
You don't need, you can keep copies of those.
yeah. So that's, apologies to say, you've even answered it yourself.
Yeah.
So,
Okay.
alright. So no,
So you can keep copies of that though, that's Stuart?
well, yeah, and not for ad infinitum for as long as you like, but having said it, it's a report that's in the public domain. You could download it and print it anytime or save it on your server if it's a complete report or a planning application or something like that. They're there in the public domain, but then if you can download it anytime you want, you don't need to keep a copy of it. So it depends. Like I say, not giving definitive advice here. Trying to give general guidance.
And is a company personal data as well? No. It's only on a person.
Yeah,
Financial data is not personal either.
Yeah. Most financial data not. If it's about a person and you name the person, well, then it's financial data about him. But normally, I mean, you can keep company records for as long as you like.
Data protection is for the protection of the information pertaining
Data
to living,
subjects.
identifiable individuals.
Yeah.
It actually ceases when you die. You're not living or identifiable. You're identifiable but not living. There are other moral codes in relation to that, but that's a situation. It's living, identifiable individuals. but identifiable by association, for example, doesn't have to have my name. But a certain sensational report of me travelling on slower dual carriageway at 100 odd miles an hour, people say, oh, that was Stewart. So,
And then when you mention processors, I mean, for example, I'd say most people in here are probably using Office 365
Yeah.
for their database.
the Microsoft and many other companies, so not to get specific, have GDPR compliant statements on their website. You're capable of getting them to give you their GDPR bona fides so that they can comply with anything you require in terms of GDPR, in terms of downloading, copying, stopping, restricting, or whatever. They have their statements online. They're all preparing for it. You can imagine Facebook's getting ready for it as we speak because they're being grilled all over the world. But just to say that, yes, companies such as that, and then if you're using any other cloud-based solution. But by the way, one thing to point out, it is incumbent upon you, by you I mean any controller or owner of a business that handles data and controls the data, to ensure that all processors are compliant. So you should be checking and have on record that you checked with Big Red Book or Salesforce or Microsoft or whoever you use, or Office 365, that you are satisfied that they are GDPR compliant for the use of, for handing over your data. So your payroll processor, or wherever it may be, or if there is such a thing, or your external HR company, or your whatever that is, they have to satisfy themselves to you that they're handling the data in a compliant way. You should have a contract with all processors, and the contract has to be GDPR compliant as well. And there are things specified in the GDPR that must be in a contract. So you may have to redraw contracts between you and your processors. There's quite a lot more than what I went through today. I'm just trying to give a whistle-stop tour, just to give you guidance on what you may need to do in your own practice, business, or profession. Doing nothing, as I mentioned, isn't an option. Yes, sir.
Can you expand a little bit on CVs? This time of the year now, you get CVs coming in their droves.
No,
People want you to keep their CVs on file,
well,
and there is a timestamp, I think, on them. But in some situations, like our organisation, we would intentionally keep CVs, and we mightn't have a position now, but in 4, 5, 6 years' time, that person would be at the right experience level, and you have their contact details and other information that's on the CV.
I was at a conference recently which was HR and the GDPR, and I was amazed at some of the, I wouldn't say regulations, recommendations, and vastly different time spans of various things. That's how so I'm not an expert in HR, I'm supposedly an expert in the GDPR. One of the things you may do there is that you may have, as part of your privacy statement and as part of your application process, clearly state to people what your intention is for those CVs, and for them to say, yeah, we would like you to hold that on file. So this is an example of how you might hold them for longer than a certain period of time. I believe that unsuccessful applicants, there's a recommendation that they're only kept for somewhere between 6 and 9 months, for example. Once, if you've got a job filled and you have unsuccessful applicants, you may hold the data longer, as long as you've told me, right, I applied to you, that look, Stuart, if future vacancies come up, would you like me to hold on to your CV? And you have to give a reasonable time. I should know. I should not be surprised to find that you have my CV after 6 years. That's the kind of information that's there. It says, I know that's not it's a very general comment, but that's the nature of it. Common sense comes into play. Okay, so 20 to 8. Nearly time for me to get into my pajamas.
One last question. If somebody was to email me personal data, like I was doing a work with somebody and they gave me their personal mobile, call me on this tonight, that gets lost in my 50 million emails in my email server. It's still in there in 10 years' time or 7 years' time. How can you...
I suppose I shared it with you, and I shouldn't be surprised that you have it. Having said that, you do have a duty to ensure that any personal data that you hold in your filing system is both protected and, as required, removed after a certain period of time. One of the things about emails, by the way, is emails also should have a retention period. You need to consider that. Just to say, every piece of data you hold needs to have a retention period, and something needs to happen to it.
I think it's because of one of the things with emails. We've all been using emails for a long time, personally, and we don't worry about them, right? We keep them on forever. They go back to whenever we started that particular email service, and we've never thought about it. That's fine, personally, because processing data for purely personal purposes or household purposes has nothing to do with the GDPR. So keep it as long as you like. But when you're processing personal data as part of a business, that's different. You actually do need to sit down and think, what am I going to do about wiping old emails? I can't keep them forever. I do need a retention period. When we talk about business efficacy, what's the point in having emails from 15 years back that no one is ever going to look at again, you're never going to use, and it's just occupying storage space in the cloud, if you like, but still occupying it. It's gumming up and slowing down your computer, if nothing else. And you need, from a GDPR point of view, you now need a retention period and some method of wiping them.
Evidence that you do it.
Yeah.
Okay. Forensic engineers with a sense of humour. He's going, holy God. Anyway, I do apologise. So look, if there aren't any more questions, I'd like to thank you all for being here. It's been fun and interesting, certainly for me. And I wish you all the best. Thank you very much.
Thanks.